It's critical that the judge trust what you say, have confidence that when you tell her something, it's true, and that there's not a spin or a different side to it. It starts actually, pre-trial, right? One thing that I do with my teams is every brief that we write, every letter that we send in, we take extra care to make sure that every fact that we assert in a letter is 100% accurate. We don't do things like ellipse out language that's unhelpful from a quote, for example. And same thing with discovery, right? People can get very excited about discovery and they can take very extreme positions. That's fine unless the extreme position makes you come off as not credible and not trustworthy. And sometimes it's better to lose, a mini battle, but maintain your credibility with the court than it is to win every point. Most judges have very good detectors for truth-telling, both with witnesses and with lawyers. As important as it is to establish a relationship of trust, you don't get a second chance if you tell something to the court that's not true. Most judges will, not all, but most judges will take that instance and form a view of the lawyer and be skeptical, or at least not fully accepting of what that lawyer tells the judge during the course of the case. When you've earned the trust of the court, you can pick points in the case to make objections that are not likely to be sustained, but still may influence the way the judge thinks about something. So, for example, before what you expect to be a difficult cross-examination for one of your witnesses, I have at times made relevance arguments during a bench trial. And judges typically don't sustain relevance arguments in a bench trial. And they're going to listen to the cross-examination. They're going to overrule the objection. But they're going to think about, why did this person who I trust tell me that this wasn't relevant? And I've had that experience with judges where the judge sort of looked at me sideways and said, really, it's not relevant? Listened to the cross-examination, came back to me and said, tell me again why it's not relevant. And then when I got the decision, what I told her about why it wasn't relevant is what she wrote. The more that a judge trusts you as an honest broker, the better things are going to go for you during trial, whether it's the weighing of the facts or what evidence gets to a jury, it doesn't get to a jury. It makes a difference.